Hello, I'm Calum Cheyne. I'm an associate at Floyd Zadkovich, and I'm talking today about bunker arrests, in particular bunker arrests in light of the OW bunkers, the Res Cogitans case in the Supreme Court of a few years ago. This is part of the Floyd Zadkovich series on how international businesses can deal with an economic crisis such as the one that we are currently living through. We're going to look first at what a bunker arrest is, secondly at what a party would need to demonstrate in order to obtain a bunker arrest, and thirdly how that is then affected by the OW bunker insolvency case. So firstly, what is a bunker arrest? It is what it says in the tin. It's an arrest of bunkers, an arrest or an attachment over the fuel on board a vessel. And typically this has a very similar commercial effect to a vessel arrest. The local court will say that they'll order that the vessel is unable to burn as fuel the bunkers on board, and that means that if the vessel continues on its voyage, it would be doing so in breach of that order. That then means that the party who have faced the arrest have the option either of keeping the vessel where it is, or alternatively taking the expensive process of discharging bunkers to a shoreside location where they can control them pending resolution of the underlying dispute. Typically you would use a bunker arrest against a time charterer, and if your claim was against the registered owner of a vessel, or in some jurisdictions the bareboat charterer, then you would be able to proceed with a conventional vessel arrest. A bunker arrest is typically brought against a time charterer, and we'll come on to why that is. But essentially, it's because time charterers are normally deemed to have to be the owners of the bunkers. So that then brings us on to secondly, what do you need to demonstrate in order to obtain a bunker arrest? Typically there will be two things. This is going to vary from jurisdiction to jurisdiction, but typically in most jurisdictions you'll have to show two things. The first is that you have a good underlying claim, and different jurisdictions will have different thresholds. Some will have a higher threshold. You'll have to demonstrate that you have a likelihood of success, for example, whereas other jurisdictions might simply require that you show prima facie an arguable case. As we say, that will vary from jurisdiction to jurisdiction, but it is important that the lawyers who are dealing with the underlying action are involved in some way with the local lawyers who will deal with the arrest, because you don't want to be in breach of any local obligation in terms of whether it's full and frank disclosure or whether it's not misleading the court. You want to make sure that you can robustly put forward your position in the underlying arbitration as fairly as possible. So the second thing that you would need to demonstrate in order to obtain a bunker arrest is you'd have to show that the party against whom you seek the bunker arrest is the same party that A, owns the bunkers, and B, is the party against whom your underlying action is. And demonstrating ownership can be difficult. Typically, if there's any correspondence arranging the bunker supply, that correspondence will be between vessel and the bunker suppliers. To the extent that there's any documentation, to the extent that there's a bunker supply contract, it's unlikely that you're going to have that. You're not going to have sight of that document. So often you'll be falling back on the charter party, and the charter party is often taken as good evidence that charterers do own the bunkers. Clause 7 of the NYPE form, for example, states that charterers are to provide and pay for the bunkers. So if you're the bottom time charterer in a chain of time charter parties, the likelihood is that you are the party who has provided and paid for the bunkers on board the vessel. And that in turn brings us on to the third part of the conversation, which is how has that concept been changed by the Res Cogitans case, the OW bunker insolvency case. And this is quite an interesting point legally. It's not one that we have seen run, but it is one where, as times become more economically difficult, as parties do seek new forms or slightly more complex forms of security, parties will be forced into taking actions like bunker arrest. And it's important to think about how you might defend against a bunker arrest if one is sought against you. And this is a possible avenue to such a defence. The Res Cogitans case was looking in detail at bunker supply contracts. In particular, they looked at the payment terms. So most of these bunker supply contracts will be on 45-day, 60-day, 90-day payment terms, where the bunkers are put on board the vessel on day zero, and the party taking the bunkers is able to burn them for propulsion over the entire duration of the credit terms, by which point, more often than not, the bunkers will have been fully burned, and yet they don't pay for them until the end of that credit period. And the court said this is not a sale of goods. It's not a sale of goods under the Sale of Goods Act. They said this is a contract sui generis, meaning it's a contract of its own. It's a thing of its own. And they found that, properly construed, the nature of this contract was that the purchaser, or the would-be purchaser under the bunker supply contract, has a permission to burn the bunkers. From entering into the contract, they're granted the permission to burn the bunkers prior to payment, but it's only on that payment that title in the bunkers actually transfers to the purchaser. So if we then think back to what we need to demonstrate to obtain a bunker arrest, we need to show that the party against whom we seek the bunker arrest are the owners of the bunkers. Well, according to the English court, according to the Supreme Court under English law, if that's the law governing the bunker supply agreement, and if the bunker supply agreement is on credit terms, and if those credit terms have not expired and payment has not been made, then there's a very good argument under English law that those bunkers still belong to the bunker supplier. Title in those bunkers has not yet passed, and title in those bunkers will only pass on payment. Therefore, any purported action to take security in those bunkers, as against the party, the time charterers who have not yet paid for them, could arguably be said to be doomed to fail. As I say, we think this is an interesting argument. We think it's a creative argument, but it's the sort of argument that may be necessary in the coming weeks and months as parties try slightly more speculative, slightly more unusual security proceedings, such as bunker arrest.